can we settle ourselves down? Make sure that your phones are on silent or vibrate, please. And we are going to shortly be commencing this breakout discussion. Just checking the time. Okay. All right. So hopefully we'll have about an hour and a half for this session. There will be an opportunity for you to ask questions and to make any comments after we've heard from our panelists, who are just going to introduce some perspectives. So welcome to all of you. My name is Esther Xosei, and this is the Law and Reparative Justice Legal Pathways to Repairing Injustice session. We have a number of panelists here, and I will introduce them as they are about to speak. So just acknowledging our panelists first and foremost. Now, in terms of this session, we are looking at focusing overall on moving towards the various institutional and policy changes that will make reparatory justice a reality. Of course, that big question of the meaning of reparatory justice and the different meanings that people have and are working to. Please come in and make yourselves comfortable whilst we begin the session. So the historical legacy of the forced enslavement of African peoples is inexorably linked to legislative frameworks, many of which were formulated and enacted by the UK Parliament and other legislatures worldwide. These laws provided the legal foundation, or I would say the legalized foundation, for a system of egregious human rights abuses, leading to immeasurable suffering, exploitation, and the dehumanization of countless individuals. So this panel will delve into the policies and governance structures that permitted and in many cases encouraged the transatlantic trafficking of enslaved people, the legislation that allowed for the enslavers to be compensated and not the enslaved, or us, their descendants. Moreover, this panel will emphasize the legal case for reparations, or cases, and that the journey towards reparative justice must also be anchored in the legal domain. So before I ask our panelists to speak, I just want to remind ourselves of some of the positions that those of us with legal backgrounds have been working with around African reparations. There's been mention of the Abuja process, which was the first Pan-African conference on reparations for chattel enslavement, colonization, and neo-colonization. And out of that, there was the forming of the African Reparations Movement UK by the late Bernie Grant MP and many others. Now, in a famous paper that was presented to a preparatory conference after Abuja in 1993, and this would have been in April, in Birmingham in the UK in 1993, there was a conference to mobilize the African diaspora, in particular, based, here, around implementation of some of the objectives of that Abuja conference. And one of the papers that was presented there was a paper called Charting an African Self-Determined Path of Legal Struggle for Reparations. And this was presented by a sister Affiong Salfi, who many will know, and it was also written by Brother Kofi Maoli Klue. And he pointed out then, and this was in 1993, the use of law is one of the most important instruments of our African struggle for reparations. Indeed, the need to locate our claim to restitution for the damages caused by the gross violations of African sovereignty must raise immediately for us the essential questions of whose framework, whose law, and whose justice. And that is really important because one of the standard lines of argument that the UK government and other European governments have been raising, especially since the Third World Conference Against Racism in 2001, is that slavery was legal at the time. And should, it should always have been so. That was the wording that Tony Blair in particular ensured was in that declaration. So even though there were a couple of European countries that wanted to go further, the UK government at the time resisted that, okay? So this question of law, whose framework, whose justice? And it can no longer be argued by any rational or intelligent person that African people did not have law, okay? And so when we hear our panelists, they have their contributions to make in terms of their own perspectives and the work that they're doing, but I will also be posing some questions to all of you as panelists afterwards in terms of this recognition around the landscape that we are working towards, and in fact, how far does your own work recognize the plurality of law, okay? And this notion of what is legal knowledge and how do we create law? What is the role of the people? What is the role of movements in legal transformation? And what is your own role? But we look forward to hearing from you. And the other person I wanted to just acknowledge is Professor Adjoa Ayatoro, who is an attorney at law in America, a fellow reparationist in COBRA, the National Coalition of Blacks for Reparations in America. And she wrote a paper years ago formulating reparations litigation through the eyes of the movement. And one of the things that she states in this paper is that for a people who have been locked out of justice, for the big crimes, okay, then in order for there to be effective repair, the law itself needs to be repaired. The frameworks, the mechanisms that we are using are not neutral, nor are they innocent. And therefore, litigation and legal systems must incorporate the language, the framings of movements and communities who continue to be impacted by various violations of their rights, their human rights, their people's rights, their humanitarian rights, and I would add our Mother Earth rights. So by way of introduction, I think I've said enough. I look forward to hearing from each and every one of our guest contributors. And I'm first going to go to my right, and we are going to hear from Clive Baldwin, who is a senior legal advisor for the Legal and Policy Office at Human Rights Watch, where he has been working on issues of international law since 2007. But just in terms of order, so that we're clear, after Clive, we're then going to go to Harj, then we're going to go to Jacqueline. I will introduce them properly at the appropriate time. And then Gretchen, we are going to come to you fourth. And hopefully by that time, we will also have Corinne in the room. So can I ask speakers to speak for around 7 minutes? I will try and be prompt, so if you get a little notice from me, please read it, because it's telling you you've got like 2 minutes left, and then 1 minute left. Thank you.
Thank you, Esther, and thank you again for your speech this morning as well, which was both inspirational and something for all of us to think about. It's an honor to be here from a global human rights organization working on issues of human rights, justice around the world. And to say the movement for reparations, this movement for reparations, is one of the most important and inspirational movements for justice in the world now and for generations in the past. Also wanted to say at the beginning, we're talking about law, and to know that law itself, the law that's written, the law that's not written domestically, internationally, and the courts and others that enforce it, have so often been a tool of oppression and used for oppression. They can, at times, they'll also be a tool for justice, for liberation, and that's where they should be, and that's part of the ways getting to where they can and should be the tool for justice, but it's so often not been the case. The other thing I would just say at the start is that when we talk about reparations in law or those sort of principles, for most of the time and most of history, is not controversial. The idea that someone, that something, that some institution, that some country, that some state has done wrong to somebody or some other people and has to put right what they've done wrong is, and is obliged to put right what they've done wrong, is not in so many cases controversial. It's perhaps only controversial when it comes to the crimes, the atrocities of certain states in the world, or it becomes much more controversial then. But the principle of reparations, even in human rights, is well established. It's set out. It's been set out in different ways by some courts. It's been set out in UN principles agreed by the General Assembly, by all states of the UN. I think other speakers may go into more detail, but knowing these principles we hear about of restitution, putting right what was wrong, of compensation, of satisfaction, satisfaction including meaningful apologies, meaningful steps, guarantees that the wrongs will not be repeated. Those are set out. Those are agreed principles. Those are even agreed by the UK government for other countries, not for the UK itself, it seems, in practice. But you hear UK ministers and others speaking at times, and they accept these principles in other parts of the world. So these have been set out at different times. You mentioned the Durban Conference, the Third World Conference Against Racism, and the Durban Declaration and Programme of Action that came out of it. It's 23 years ago, so it'll be the 25th anniversary in a couple of years. States agreed to some of these principles then, declaring crimes against humanity, enslavement, trafficking in enslaved people, especially the transatlantic chattel trafficking. They used older terms then, but those principles were established then. It was a declaration of all states. It was watered down, as you said, by the UK, by certain other European states and the US. But these are principles to start with and to build on, not to set in stone and freeze. I'm just going to be brief today, so we have time for discussion, but also to mention the tools. And one of the tools, and we're saying where does law come from, is knowing, sometimes in human rights terms, you hear about domestic countries, you hear about the European Court of Human Rights, but there's very strong traditions in human rights in different countries around the world, and those are ones to be taken notice and follow. The African Charter on Human and People's Rights, it has rights of peoples in it. It's one of the most progressive documents in the world. It's one to be followed and looked at, including the bodies which are set up to implement it, Commission and Court. Similarly, in different ways for the Inter-American System of Human Rights, which has recognized, say, the rights of indigenous people, the rights to remedy in different ways. So knowing this, but is the United Nations in different ways that can set the standards and helps. And I'll just mention briefly the International Court of Justice, the World Court. This court itself is made up of nominated judges from different states. It does, in many ways, historically, has a pretty bad record in addressing racism, in addressing apartheid, in addressing colonialism. Well, there's several rulings it could say and could set out how bad they were, and they are closing their eyes to it. But a couple of improved, perhaps some moments to take note, especially in the last decade, in that there's been two what they call advisory opinions. This is when the court asked, in most cases by the General Assembly of the UN, to give its opinion on certain issues. So it's the states in the General Assembly who request this, and they have now requested two in the last 10 years. The first was on the Chagos Islands, the decolonization of them. Again, that was requested against the bitter opposition of the United Kingdom. And that was 5 years ago, and this year the court ruled an advisory opinion on the legal consequences of Israel's occupation of occupied Palestinian territory. Just to note on that, I'll come back to Chagos in a minute because we are hearing about that now. But the ruling, its advisory opinion on Chagos was seen as one standing up and saying the right to self-determination is a principle. And now it's said in the Israel-Palestine case this year that it's a fundamental principle of international law. Again, going against bitter opposition from many Western states, both even at the General Assembly and at the court itself. But to note, the opinion on Israel's occupation this year is addressing there's many things it addresses, but on reparations, it addresses very strong language. It just says Palestinians have a right to reparations for all wrongful acts committed against them since 1967. So it's saying historic. And then afterwards, the UN General Assembly, as a result of that ruling and the suggestion of a South African judge, Judge Tudley, has called for the setting up of a mechanism for reparations and a mechanism for a register of damages for reparations for the Palestinians in that case. So that's action from the ICJ. And then just to briefly mention the Chagossians, because that shows the limits of international law as well. So the ruling on the Chagossians, although it mentions the harms done to them, did not address reparations. Some of the judges said it did. And to say now we're hearing that that ruling's led to a treaty, it seems, between the UK and Mauritius about the territory, but the Chagossians, as you may know, an African people, descendants of enslaved people, forcibly displaced in the entirety by the United Kingdom with the United States behind it, a crime against humanity, forced displacement, racial persecution. Will the treaty address reparations to them? Will it address their right to return to all their islands? Will it address compensation to them, which will be agreed with them? And will they have the right to participate and be consulted in their decisions about them? For many reasons, it seems the UK government, although it may allow some return, it may allow some payment, is not recognising the principle of reparations there. And if it does not do so for Chagossians, where it regrets what's happened in different ways, where it acknowledges the wrongs of the past, where will it do so? But to say there's a key moment for the changes in the international law we need and for the implementation of international law for reparations for the worst atrocities in history are finally done, but only with the people and not over the people. Thank you.
Thank you for that introductory presentation, Clive. We're now going to move on to Harj Narulla. Is a barrister specialising in climate law and litigation. He is an experienced climate lawyer who acts in a broad range of domestic and international climate litigation. So let's hear your perspective.
Thank you, Esther. Good afternoon, everyone. It's a real pleasure to be here. Thank you to the APPG for inviting me, and to Belle, who's just walked in, for the invitation. It's a pleasure. I was at the conference last year and I found it to be a really wonderful event, and I think today's lived up to that example. So I'm going to be covering 3 points today. Firstly, I'll briefly touch on why I think litigation to achieve reparations for slavery is possible. The second point I'll go into is talking about how reparations as a broad concept operates under international law, and how it can be used, I think, for a range of both monetary and non-monetary forms of reparation. The third point I'll talk about is some leading climate change cases that are happening right now before international courts, which I think will be very helpful for developing reparations cases focused on the issue of slavery. So before I get into those 3 issues, I just want to say a little bit about my practice to give you a sense of where I come from with this issue. So as Esther said, I work predominantly on climate change and environmental issues, with a lot of my work being in the international plane with clients in the global south. So I've represented Indigenous communities in Guatemala, Mexico, India, Bangladesh, and Kenya, and I've done some work in Nigeria and across West Africa as well. But in the last 2 years, I've been working on 2 major climate change cases, which I'll come on to speaking about later, before the International Court of Justice, the Inter-American Court of Human Rights, the Regional Human Rights Court for the Americas, and a third case before the International Tribunal for the Law of the Sea. So as Clive mentioned, these are what are known as advisory opinions, so they're not contentious cases between 2 parties, but it's the courts expressing a view about the state of the law, and it's those different courts talking about what different countries have to do in relation to climate change. And that's relevant today because the focus of 2 of those courts has been on reparations in the context of climate change. I also have some academic roles at Oxford and at LSE. And as part of my research, I've looked at the history of French and British colonialism from the 16th and 17th centuries onwards, mostly from a climate and environmental perspective, but obviously that takes in the history of enslavement. Okay, so I'll start with my first point, which is essentially the idea that I think a legal case or a range of legal cases are possible when it comes to reparations for slavery. So I'll disclose that I'm currently instructed by a number of Caribbean states who are exploring the issue of reparations. So there's a limit in terms of what I can say in kind of technical legal detail on this topic. But speaking at a higher level, I think the first thing I'll say is that we haven't had a case in the international plane on this issue yet. So I regard this as something that's fundamentally untested in international law. There have been a number of cases in the US filed in domestic courts which haven't gone very far. And there have been other types of litigation, some of the examples that Clive mentioned, which have looked at colonialism and have implicated Afro-descendant communities. But we haven't seen explicit cases focused on the question of reparations for slavery. There are other helpful cases in related areas, such as the Mau Mau settlement that was reached by Jackie's firm in Kenya, and the Herrera case in Germany. So there are things that we can start building off of, but there hasn't been a direct case. So to me, this is fundamentally an untested area, and therefore one of legal possibility. So my second point here is that there are a number of international courts in particular where a case could be tried. So the most obvious one, I think, is the International Court of Justice, the World Court. It has the competency, the ability to look at this question, and Clive has mentioned that already. That could take the form of an advisory opinion, speaking in general about the principles of law, or a contentious case. So a formerly colonised state with an Afro-descendant community bringing a case against a Western European government. That would be a contentious case. There are also other international fora, such as the Committee on the Elimination of Racial Discrimination, where I think you could file a case as well. So my third point on the fact that I believe that a legal case is possible is focused on domestic options. So I think that while it's more likely that you'll see an international case, I think domestic litigation is also possible, and that can take a few different forms. So a number of states, independent states, still have rights of appeal to their former colonisers. So states such as St. Lucia, Dominica, Jamaica and the Bahamas are able to appeal and bring cases to the Privy Council in the UK, for example. There are also overseas territories such as Bonaire and French Guiana that have a similar relationship with the Netherlands and with France. And what that means is that there is an ability to bring domestic cases by states and by overseas territories focused on this issue of slavery. I also think it's possible to bring cases against corporations and other non-state actors that have been implicated in slavery, such as the Bank of England, for example. I think that those cases are slightly more difficult because of legal issues such as causation, so showing responsibility for it. But I think that there are potential arguments in tort law and potentially under unjust enrichment and human rights. Okay, I'll move on to my second point, which is speaking about reparations as a broad concept under international law and the fact that it can include different types of remedies. So Clive already mentioned the framework for reparations. There's a legal framework called the Articles of State Responsibility for Internationally Wrongful Acts. And that sets out that reparations can take the form of restitution, compensation, or satisfaction. And there's a hierarchy there, where there's a presumption that you'll firstly pursue restitution. So these are non-monetary forms of reparation as a way to try and essentially reverse the harm or undo the harm such that the victims are in the position they would have been at before the harm occurred. So examples of restitution are things like returning land, returning stolen cultural artefacts, education and awareness, funding for healthcare, political inclusion for victims and discriminated against groups, and debt cancellation. So the second of those frameworks for reparations is compensation. And so this can happen alongside restitution, or if restitution is not sufficient. So this is obviously financial payments to victims to try and recognise the harm. And the third is satisfaction, which essentially includes things like apologies and other forms of recognition like museums and other symbolic gestures. The key point I want to make here is that there's obviously a thriving debate as to what reparations is, what is just, and what is required in each individual context. It's a very complex conversation. All I want to say is that, the law is a broad framework that I think can accommodate a lot of those different demands. Third point I'll go on to quite quickly is that there are some climate change cases happening at the moment for the International Court of Justice and the Inter-American Court of Human Rights, which are looking at the issue of reparations, as I mentioned earlier. And I think these cases will provide a very useful legal platform for a future case for reparations for slavery because of some of the conceptual similarities between thinking about creating responsibility around climate change and responsibility around reparations for slavery. Both are very large historical injustices that have taken place over hundreds of years. You have a very complex picture of legal responsibility and a lot of the principles that are being developed there in relation to, for example, calculating non-economic loss, so a loss of culture, for example, is something that could be used in the reparations context. I think because I'm at time, I'll leave it there, and I'll just summarise by saying that those two cases I just mentioned from the International Court of Justice and the Inter-American Court of Human Rights, they are due out in the middle of next year, and I anticipate that off the back of those you'll see small island states in particular, and states in the Global South, bringing climate change focused reparations cases against North America, against Western Europe. So I think that we have entered into the era of reparations as a legal tool, and that we'll see, I think, similarly develop in this space in relation to slavery as well. Because I feel that fundamentally, if the cause is just, then law will find a way. Thank you very much.
Thank you. Thank you, Harj, Narulla. Now moving swiftly on to Jacqueline McKenzie. Jacqueline McKenzie, partner and head of immigration and asylum law at Leigh Solicitors. She was a member of the independent advisory group that delivered the Windrush Lessons Learned review in March 2020, which resulted in an official apology from the Home Secretary. Thank you, Jacqueline.
Thank you, Esther, our esteemed chair, esteemed panelists, and all workshop participants, all protocols observed. I think the other two speakers, Harj and Clive, have actually said some of what I was going to say. So I think I'm just going to put my own little touch on reparations more generally, and then talk about the legal framework, and then what I think we should be doing. I want to start by honouring our ancestors who endured and survived the most brutal systems of kidnap, enslavement and degradation, so that you and I could be here to be fighting in their names and in their honour, for future generations of their descendants to be treated with respect, dignity, equality, and have the opportunities for attainment that they have long been denied. I'm grateful to Belle Ribeiro-Addy, MP, and the APPG for once again bringing together such a diverse group of expert voices to explore our understanding of reparations, to outline the nature of our work, to learn from each other, and to agree a series of recommendations or a methodology for synergized working so that we can achieve the aim of reparations for the ill consequences of the transatlantic system of the enslavement of Africans. We are in a phenomenal era, not because of the activities in Chogum in Samoa this past weekend, but because you have made that happen. And so I want to do as I did last year, acknowledge and give due respect to the reparation campaigners who have been working for decades to seek reparatory justice for the lives lost, the brutality of the transatlantic system of the enslavement of Africans, the loss of opportunity for Africans in the Caribbean, the Americas, Africa, and the diaspora, the destruction of identities, cultures, and economies, all of which have consequences which last to this day, the consequences of underdevelopment, inequality and racial mistreatment, situations made worse by the impact of climate consequences, the desperation of white supremacy, and the worldwide economic crisis with its resulting social crisis. There are counter views on what reparations is and means, who the legitimate voices are, whether or not there's a legal, moral, or political case, or a combined approach, who should receive it, whether it should be money, projects, the development of infrastructure, debt forgiveness, restoration of artifacts, etc. The critical observation to be made, though, is that reparations must feature at its centre the victims of the perpetration of a crime against humanity. This is one of the concerns that I am sure most of you will have thought about as we see governments leading these initiatives. I don't think there was a single representative of any of the CARICOM reparations commissions or of the AU commissions in Samoa this weekend. I'm just going to deal very briefly with the framework for reparations, and some of it has been touched on, so I will skip and might seem a bit disjointed. There is no known legal provision which determines what reparations is. In international relations theory, it is regarded as a concept rooted in international humanitarian law that involves specific forms of repair to specific individuals, groups of people, or nations for specific harms they have experienced in violation of their human rights. It involves that there is a remedy recognized under international law for victims of serious violation of international humanitarian law and human rights, and I'll skip all the articles because they were mentioned. Indeed, victims' rights to reparations is non-derogable and a fundamental principle of international law, which can be enforced either at the international or national levels. The task for us is to build those cases. The United Nations Basic Principles and Guidelines on the Rights to a Remedy and Reparations for Victims of Gross Violations of International Human Rights Law and Serious Violations of International Humanitarian Law describes 5 formal categories of reparations: restitution, compensation, rehabilitation, satisfaction, and assurances of non-repetition based on an individual or collective experience. And we've seen state-led initiatives, the most well-known obviously being Germany, paying reparations for the Holocaust. We have also seen international compensation funds set up for victims, and these have been created through the United Nations systems and by the International Criminal Court, and governed by international, of course they're normally dealing with war, but governed by international guidelines on reparations to victims. And victims' reparations are also implemented by regional human rights courts, and Harj mentioned some of those. The jurisprudence of the ICC and the International Court of Justice helps to clarify the interpretation and the implementation of the various principles of reparations to victims. Reparations for the enslavement of Africans is likely to be at the level of state to state. Africa and the Caribbean versus the diaspora, versus Europe. And where does that leave the diaspora? In this respect, it is the ICJ that has jurisdiction to resolve such questions of interstate responsibility for reparations. According to the established ICJ jurisprudence, the responsible state must first endeavour to provide this reparations to re-establish the situation that existed before the wrongful acts was committed, and where that's not possible, to provide cover any pecuniary loss, including profits, and I would imagine that it would be very difficult to restore Africans to the place we were prior to the transatlantic period of enslavement, though others may argue against me on that, and I'll be happy to hear those arguments. In 2001, the International Law Commission adopted 59 draft articles on the responsibility of states for internationally wrongful acts, and these articles are considered a key reference in international law and have been widely cited and applied in state practice and by international courts and tribunals. So the framework is there. In 2005, the UN Commission on Human Rights adopted the basic principles and guidelines on the rights to a remedy and reparations for victims of gross violations of international law and serious violations of international human rights law. These were reaffirmed in March 2006. These principles, I kind of realised my time, 7 minutes has gone, so I'm going to race now, because I haven't actually got to my main point. These principles emphasise the specific obligation of each state to provide adequate remedies to victims of violations, which are often committed by its own agents. And the fact that human rights violations are often perpetrated by state agents makes them more difficult to sanction and increase the vulnerability of victims. The UN principles insist on the need to include in national legislation appropriate provisions, and I'm going to skip all of that because I want to come on to you already know that the jurisprudence is set within the International Criminal Court and the International Court of Justice. I wanted to go through some examples, but I think I'm just going to get to the end of it and say, I think we have some real difficulties with the courts and looking at legal challenges. And I agree with Harj that I don't rule that out. We are working together. We are looking at building some cases. Obviously, at the moment, we can't go into the details of those. But we've seen some really terrible examples which we think provides us with these challenges. So some of you will have seen what happened with the Tulsa race massacre case where an Oklahoma judge has dismissed it. It's also been dismissed in the Supreme Court there, locking that down. And I think that we're going to have a right old time with judges on these issues, mainly because of who they are. Certainly don't want to do anything that's going to get me struck off tomorrow morning when the regulators say I'm having a go at judges. But I think it's going to be very difficult to get judges to be on our side where there is scope for discretion, as there is often in a lot of these sorts of cases. And what was so disappointing about the Tulsa case was that the victims are still alive, or that there are some of them still alive. And then we saw also last year too, because this was last year, 2023, we've also seen the Court of Cassation in France, France's highest court, reject a claim for reparation from Guadeloupe and Martinique. So we don't necessarily want to rule out legal cases, but we want the community and those impacted to be Esther, my time is up. So, no, I know. Oh, so, okay, so I'm going to miss out all the bits about intemporality. I'm going to miss out all the things that I think we can challenge and just come very quickly to say that we do believe that there is some legal cases, and we're getting more and more excited about them. But the big, and of course we are going to, we need to get states to seek advisory opinions in the Court of International Justice, file an application to the UN Committee on the Elimination of Racial Justice. There's some individual things going on with some of the institutions and some of the organisations, like the Bank of England. We're very excited about this idea that those countries, those British overseas territories that are still British colonies, may well have an action in the domestic law. It's just something that's literally we've all been thinking about recently. And also those independent territories that still have the Privy Council as their lies. I mean, I think last year we spoke about some work that might have been going on with Jamaica, and that stalled a little bit, but we can find another country to bring that case. We've got people like the descendants of the Codrington estate in Barbados. We've got workers on the Drax estate, all looking at individual ideas. But I just want to end by sounding a note of caution. We do need to set up a statutory inquiry or a commission of inquiry. Those interested in reparations need to come together and form some sort of very strong commission that is subdivided with education and culture and artifacts and the law. We need to have that. There isn't that organisation in the UK to really deal with it, because the UK is going to be fundamentally important in this struggle. But what we're going to see are CARICOM governments wanting to, as we saw in Samoa, and brilliant, and I actually wrote a briefing for them, for the High Commissioners for Samoa, and we're delighted that that they were brave and that some progress has been made, and we've got a declaration, and that Keir Starmer was forced to sign it. after making those offensive remarks at the start of it, that there was going to be no apology and there will be no reparations. And it was the same that Theresa May did on Windrush. I know it's nothing to do with Windrush today, but it was the same thing. And then the CARICOM High Commissioners pitched up in London for the same CHOGM, but it was in London in April 2018, and Theresa May was forced to give the apology and set up the compensation scheme. With all its problems, it's there. So we need to think about, my final point, we need to think about, we've got these governments, and you know the Caribbean governments, and you know, somebody might say, well, here's a deal. I mean, we saw Jamaica once accept a prison in return for not deporting people there. So they may see some deals that are very good, but those deals exclude the people. So we've got to work that out. We've also got to work out how we continue our work on the legal cases, because I think it's that will put pressure on the CARICOM governments and the AU governments to accept better deals. Thank you.
Thank you. Thank you, Jacqueline. Okay, because we are still supposed to finish by 3:30, I'm trying to move us swiftly on. The next person that we're going to hear from, we're going to hear on screen and see on screen, that's Gretchen Rohr. I hope I've pronounced your surname correctly. Gretchen is a strategic litigation officer for the Open Society Foundation based in Washington, D.C. Thank you, Gretchen. We're going to try, we can't hear you, maybe, is it on mute? If you try and stick to 7 minutes, try and stick to 7 minutes, please, Gretchen. Thank you.
Great, thank you. I'm hearing a bit of a feedback, but how's it sound for you all?
Yes.
Okay, great, thank you. Well, first, I very much want to thank, I'm going to ground myself in recognizing and thanking the Anacostan Piscataway Nation, of whose unceded territory I stand right now, also known as the District of Columbia, which many of you, I'm sure, will feel great familiarity with as still operating as a colony. We do not have the right to represent our own government and representation in the federal government, as well as to create our own laws, including those affecting our criminalization and where those who are deemed criminal are punished. So this work, I know, is standing on the shoulders of many that I do not even know of, aren't aware of, and want to give gratitude to that, because I do believe it seeps into the land, and there's a lot we need to learn from the earth. Really, that informs us as we get to the point of the law, not to just get too far off on that. But I also really want to thank the organizers, most specifically the Honorable Belrivia Adi. Yes, thank you so much. She's amazing, and keeping us all connected, and bringing this, and all the other parliamentary members, bringing this together and inviting us to be able to problem solve with you. And then I want to thank my fellow panelist, Jacqueline. It's just been such a joy to be able to have, I think, see you as almost like a sister in the struggle of taking our time of just not allowing the ceiling of imagination to prevent us from just really thinking of what are some solutions we can move forward. My work has been informed by incredible organizing in the United States, the Reparations campaign that was driven by a number of different groups, but one of my strong colleagues, Joey Mogul, who advanced Chicago's reparations legislation, which was much more comprehensive than the small amount of reparations work that I had supported implementation in my first few years litigating in the U.S. And supporting Holland and Knight relating to the burning of a Black town in Florida. That has really shown me how long it can take to be able to get any implementation, any resources, and anything tangible to those who are harmed. And I move forward with that knowledge and that memory. I also want to thank, and I know I've taken most of my time just with gratitudes, but do want to thank Mary Hooks and the Movement for Black Lives and the Lawyers for Black Lives, which I believe that they do have a model that is very useful for us to understand absolutely. The complexity of us, of being able to align ourselves globally and organize, and the possibilities that taking such a catalytic moment of the series of organizing in various localities on the violence against Black people in all forms. Their framework of reparations actually preceded and predated a lot of the focus of what the global attention was to police violence, and it maintains and it continues to be so. And so it continues to inform my work. And in one of the materials that I would hope that you all would look at one point in time, Movement for Black Lives has its workbook on reparations, and it's the quote of Mary Hooks that essentially identifies that for those who are surviving descendants, our obligation is to redress the suffering of our ancestors, to gain the respect of future generations by what we do right here, right now, and to be transformed in the process. And so if there is time allowed, I really would love to talk about some of my suggestions as to how we can hit all three of those points. What has really gotten me here, and what is my role? As I said, started to do a little bit of work in the US relating to reparations, but then went and focused more so, actually did some reparations work in Southern Africa, and when I was with the Rhodes Scholars Trust, which really was trying to pull that money and move it in on a very small scale. And then shifted to class action litigation work and human rights work in the South, and then served time on the bench. So I have a very complicated relationship with the law and how colonization is most definitely driven and advanced by these laws that were constructed to enforce it. When I departed, it really was to help resource and define our new systems of justice. We had to expand beyond it. And did that mostly by resourcing and working in partnership with a lot of the folks who are queer and Black-led justice movements in the US. I was excited to be able to return back to the work of litigation with the Justice Initiative with OSF. And it's there where I spend much of my time behind the scenes, but working full-time on our reparations and building out our reparations work. Specifically, it is advising key decision makers, whether it's heads of state or corporations, on how they are wishing to and addressing reparations initiatives. It's resourcing civil society and mobilizing groups that are also exploring and trying to look for templates for action. And I've also put some time in and been really happy to work with UN Permanent Forum for People of African Descent in their first convening, held and built out training, or actually network building opportunity for all litigators around the globe, for us to start a network on reparations litigation. And that work has been taken over and led by others in attending the subsequent forums. I'm really happy and excited to see the growth of it and how we can build on this list, particularly building the capacity of those of the African diaspora to not just simply bring cases, but to design and build the law, because that is correct. I really appreciate and agree with all that is said before me. We are at a space of being able to build this as we go, and it's what brought me back into the law. It's what brought me back into having the faith of having impact, because I think we can do that at this time. There are two movements that I am resourcing, and I very much try to be I try to be specific in stating that we are in a moment of reparations movements. There is movement, and there are movements, and the destruction of the one, the silencing of one, the definition of one may have an impact on others. So it is critical for us to work in greater collaboration, to remove our gatekeeping, to find ways where we can cross-resource each other. And the movements that right now I've been putting most of my time and support in is that's being driven by civil society players as well as CARICOM relating to the double debt and the debt that was imposed on Haitians in 1825 and 21 years after their independence. And our exploration on that is not specific to the legacy of slavery, but as to the imputation of a threat of slavery on an independent country at a time when slavery was actually, when there is demonstration within public international law and other mechanisms that it was unlawful at the time for an reinstitution of slavery at the time in Haiti. That case is mostly a basic restitutions claim. The calculations as to what was stolen are well documented, including the gold that was stolen subsequently in the attempts to execute on the double debt by other actors beyond France. In addition, I've been working with, so I do want to recognize the Haitian American Foundation of Democracy, as well as FOCAL, our initial partners who are working within the Open Society Foundation Network and now are building out. They've been working mostly on the cultural expansion of education. I see, and in an answer to the question, thank you very much, Chair, on what needs to be done by us. More collaboration with culture creators, content creators, and other advocates is critical for lawyers. In the Chicago case, the campaign started by public memorials being crafted and organized by artists, die-ins by young folks in public transportation spaces. We have to do this together in multi-layered, multidisciplinary groupings, and to do so requires aligning, maybe not necessarily having the same strategy, but aligning our strategies. And so it's been a great pleasure to be able to work with those who recognize law in and of itself is narrative change. We can, as been charged by
Gretchen,
us in the initial
wrap up? Sorry to rush you.
In the initial remarks, we as lawyers can contribute to the epic stories, as best described, of what reparations is. And I believe that there are stories that exist that will compel public consciousness.
Okay, sorry, Gretchen. Thank you for your contribution. We do have to wrap up because we have one more contributor and we would like to hear from our community members here today.
I'm happy to take questions about the work on the Namibia case and the right to participation. Apologize I did not get to those points and some of those others, but thank you so much for having me.
Thank you, thank you. All right, moving swiftly on, we're going to hear from, not last but not least, Corinne Elle, who is a UK-based lawyer and senior consultant in London and Paris, PCS Limited, providing advice in corporate finance, private acquisitions, commercial law, family law, but also in budget control, human resources and management. So let's hear your perspective.
Thank you to everyone. And I want to say thank you to Kofi Mawuli-Claude, and lots of you might know for his wisdom. And he's always, I call it maker de roi because I'm French. He's building king and he's a mentor to me. And it's because of him that I'm here today. I also say thank you to our MP, obviously, Belle Ribeiro Adi, who also stands for justice. May God protect them all. We're here to talk about reparation from acknowledgement to action. And first of all, I want to talk about acknowledgement. We have a short period of time, so I'm going to try to be as short as I can. It's very difficult because I'm passionate. I can speak till tomorrow morning if you want to hear me. We should admit, first of all, that our expectations for reparation are different. That is a huge issue for us. When I say us, all of us, all African and Afro-descendant. Some of us need to be repaired psychologically when some of us are in need of food, basic needs. And that is huge. Either way, where we are, and we should support each other, and I'm supporting all of us, and thank you so much, Jacqueline, to be there for us. thank you for my friend here. I mean, he says something that I really like when he say that if the cause is just, the law will find its way. Now, I'm tremble when I talk about reparation because I'm from Africa and I will focus into the African continent today. Allow me to do that. First of all, because we're getting angry. We're talking and talking for years and years and years. And 9 million people are still dying of hunger. So we are doing something wrong somewhere. In addition to that, 875 million are still suffering from malnutrition. Nothing has changed. Let's agree, nothing has changed. So obviously, you can understand why upset I am, because I'm going back and forth from my country in Africa, from Cameroon, and I'm crying and I'm suffering inside. Now, I want to give you two acknowledgements, two main examples that I have, which we lawyers are very concerned, which is Areva. And I'm taking that example because I'm also French. Areva is now known as Orano since 2018. What Areva is doing, Areva, as all of you know, is a French company that has been exploiting uranium in Niger since the 1970s. They signed a contract that I've seen from my eyes, that I have in my computer, where they agree with the government in Niger to actually steal uranium for free and pay peanuts. When you see that, you can only be upset. Why? Because needless to say that since they have been there, the soil is contaminated, the air it is, the water resources, radioactive substances are flying into all over. Mining consumes massive amount of water, massive. It is a desert region, means that is desert. So the water is actually very, very rare. This has worsened the water crisis. The local community was suffering and drinking water from shortage. This is where we are living these days. This is in these days. It's not about slavery, because people tend to say, oh, slavery is now. We talk about now. Reparation is about now. So residents there are exposed to high level of radiation, high, leading to health problems like respiratory illnesses. I invite people to travel to see people, women having children born with disability because of Orano, because of them. So we have cancers and other conditions related to toxic exposure. Reparation, zero. Another example that I want to take is because we are here in Britain, British Petroleum, BP. Let's talk about BP. BP has similarity caused extensive damage. BP began exploiting oil in Africa in the 1920s. They find oil in Libya in 1954. They discover oil in Libya. Where are we today? BP is still active in Nigeria, Angola, Mauritania, Egypt, and in Libya. The pipeline now is so bad that what they're doing, thousands of people die because of the profit of BP. I said thousands of people. And they are polluting the water where people can't fish anymore, means cannot eat anymore. People are relocated because of BP. That's where we are. Not only that, people who are trying to fight are creating pipeline. The pipeline are polluting in entire villages where residents, I can't describe because we are going there and we're seeing what's happening. Militia are going to the pipeline, you've surely seen that on TV, try to steal petrol. People have burned skin everywhere. Cars are exploited because of this illegal way of taking the petrol. Because we're talking about poor people who just need to eat. Reparation, zero. And we are talking and seeing each other every single year. And me as a lawyer, I'm like, what can I do for these people? And that's why we're here today. You really think in a capitalism system where we are now, a government will ask to BP to be fair and allocate part of its profit to the reparations? It's not going to happen. Despite the enormous revenue that those people are doing, nothing is happening. So that means the only way is the law. We must reflect and stop the inequality using the law. We need to bring action. We need to be together, because when we're going to go to court, they will listen to us. Not only they're going to listen to us, but we can use this tool to re-educate our people and their people. Because it's important to say, miseducation is not just for Africa. It's also here. It's also in France. The young generation doesn't know what we have been through. They're on TikTok. So we need to bring case law so that we can go back and say this is what is happening now, and go through the media for the people to be with us in this very important cause, because people are dying. People are dying because of the lack of reparation. Because of the PARISC and thanks to coffee, I've been privileged enough to meet two of the three presidents in this progressive country, Burkina Faso, Mali, and Niger. I have met President Goïta. I didn't have the chance to speak to him one by one, but I met President Chiani, and I've been able to see him one-to-one, and I explained to him why the reparation was important. I told him that we intend to make another application, just my humble friend there, and go to the ICJ. We cannot go to ICJ if a government state doesn't back us up, because the ICJ is going to say the government needs to be the one to bring the claim, not you personally. So the only way we have now to take is to use the people and testimony of people to bring the action to court. It means we need tremendous fund to go there, get the testimony of these burned people, of these people who are dying from cancer, of those pollution on the ground. Huge effort, a lot of work, going there, informing the government, take the testimony, bring it back, liaise with my honorable friend here, liaise with all the legal framework, the barrister and all these people to prepare something. So we are ready. I want to say we are ready. PARISC is committed to convincing those progressive presidents. And I am going to be in front line, but I need to go back to them with something well-drafted, prepared legally, so that they can say, yes, we are with you on it, and also contribute financially, not just us as people. Hopefully, luckily, I should be able to meet the President Traoré soon, if God is with us. But I want us to understand that we need to repair all of this together. We need to elaborate a plan and be collectively and individually together. We should contribute to all the fundraising. And thanks to all of you who got organization fighting, it's because of you that we're getting hurt. Africa is waking up. Africa is waking up. It's very important. We also watch TV over there. So I'm meeting a lot of people now determined to say stop to all of this. And I'm sure together we're going to be able to make something and push things forward. Thank you.
Thank you. Thank you to Corinne, Elle. Okay, so we've now heard from all of our panelists, and we're going to open up if you have any questions or comments. But can I ask if you can make your way to the front, because those who are listening on Zoom will not hear us unless we use this microphone here at the front. So please make your way to the front if you have a question or a comment in relation to anything our panelists have said, but also the general framing of this, the role of law when it comes to effecting and securing reparative justice. And a lot has been said. There are the questions that I have around, okay, we've heard about need to take cases, advisory opinions at the ICJ, the International Court of Justice, and more. But what does this mean for ordinary people? Ordinary people who are dying, suffering, those of us in this room, what is your role? What is the role of the people? So, okay, some lawyers and other state actors in the international arena, how does this benefit the people? Okay, can you state your name and make your brief question or comment, please? No long statements.
Hi, good afternoon, and thank you for the conference. Thank you. It's for the legal eagles on the panel. Will your notes be available? Because there was a lot of articles mentioned, and some of us would like a bit more extra research to do. Harj, you mentioned the Chagos. Yes? Chagos Islands, yes. And now that they're being given back to Mauritius, yes, that's fine. I don't think so. Is there an argument to fight to get it back? Because trust me, when that announcement was made, some of us were in Geneva at the Human Rights Convention. I'm like, are you seriously kidding me? Because we remember in 2016 for CERD, when, oh no, the Chagos Island people are okay. Next thing you know, last year, they're all being shipped to Guildford and living on the street. So could I just ask you later on if you could meet me for some more information?
Okay,
thank you.
Hold your response.
That's
Harj.
Chagos.
Thank you. We're going to take several questions or comments at a time, and then we'll invite the panel to respond.
Thank you very much, and once again, thanks for inviting me. Thank you for being here. My question is very simple, actually. if slavery, as to use the term, was legal, then why did they pay compensation to the plantation owners? What were they paying for? As far as I can see it, you only pay compensation to right a wrong financially. So if they say that slavery was legal, then what was the point of paying compensation? Thank you.
Okay, thank you for your question. Moving on.
Okay. My question is actually about, Jackie said about when we have to fight reparation. We have to go through our governments. Now, if we know that our governments are enslaved by those who colonized us and who also did the harm to us, because in today's governments, it's 3% of the current governments that are running Africa that are true representative of those who were wronged by the people that we have to claim reparation from. Because my people are sitting with the same case. I'm from the Overherero people who were genocided by the Germans. And we are struggling to get the case on, and our own government is preventing us from doing that. What help do we get?
Thank you for that. All right, we're going to hear yourself, and then we'll give the panel an opportunity to respond.
Okay,
the rest of you, please do line up. We'll go a second round.
Okay, my name's Adolfo Ashanti. I heard you mention that the Tulsa Race Massacre, 1921. I was under the impression that the DOJ in America is investigating this. Can we all have some clarification where that's concerned? Thanks.
Thank you. So the rest of you, just stay there. We're going to just give the panel an opportunity to respond to those questions and comments.
I might actually hand over to Clive for the Chagos question, because I think Human Rights Watch has been doing some amazing work in that context. But I'll just briefly answer the question on compensation and what actually happened when slavery was abolished. So the question was essentially trying to understand what was the legal basis of the settlement where the British government, at the point at which they abolished slavery, rather than paying compensation to the people who've actually been harmed, i.e. everyone that was enslaved, they paid compensation to all of the slave owners. I think it's a great moral crime, that decision. It's one of the worst legal decisions that's ever been made, but it's entirely understandable in the logic of that time, which is that people were viewed as property. These people, the plantation owners, were owning property, and the act of abolishing slavery was removing that property from them. And so they claimed, they lobbied the racist government to be paid compensation for that loss of property. So it's a logic that I think today is very hard to relate to, but that was the reasoning at the time, and it's led to an incredibly unjust situation in which you have the state paying reparations not to the victims but to the perpetrators. So that's one of the bases in which I think we need to incorporate a case for reparations. I think can address that amongst other issues as well. But I'll hand over to Clive for the Chagos question.
Yeah, thank you for the questions. And on Chagos, and just for full information, I have been working with the Chagosians in some of their litigation and with Human Rights Watch for 20 years now. But I think just as a little very brief background as well is to know that Chagossians in different groups have brought an extraordinary amount of litigation, have used the law, have struggled in many ways, in different ways, against their crimes against them. But law's been one tool, and it's sometimes worked and sometimes hasn't. They've won extraordinary cases in the UK, which have been overturned. But, and it's only one other tool of litigation. It's because of that litigation that we know some of the reasons what happened. The forced deportation of the entire people 50 years ago was based on racism and lies. And that's in the documents which are being public. What should happen now? Would say there's a deal being done about the territory of Chagos, but what will happen to the rights of the Chagossian people? Will it be there? Will there be an acknowledgement of the right to return? Will they be excluded from the main island of Diego Garcia, which will be a continuation of the current colonial crime against humanity of forced deportation? Will they have the right to compensation on the principles of reparation? Or will it be, you can return to some degree, the UK will give some money, but it will be in terms of development assistance. And as we know, development is not reparations, charity is not reparations. And finally, will the Chagossians be part of the process? Will they be consulted? Will their rights as indigenous people be recognized? Or will be another deal be done about them, without them?
Thank you. Are there any other responses, Jackie?
Just very quickly, June, you can have some notes. And the question about why was compensation paid if slavery was illegal? Did you mean illegal or legal? Sorry, I wasn't sure I understood that question, actually. If it was legal. If it was illegal, I think you meant illegal, wasn't it? Yeah, well, who knows? It's politics, isn't it? And which brings me to the point that much of this is going to end up being politics, I think. I thought the Tulsa race massacre question, unfortunately, no, the case has come to an end in the Oklahoma Supreme Court. You probably saw 2 years ago, it's gone through all the various stages. It's reached the Oklahoma Supreme Court now, and has been refused leave to the federal Supreme Court, so it has actually come to an end. You may have seen one of the political candidates, I would imagine perhaps a Democrat candidate, saying they might look at it, because that's what often happens sometimes if you lose a case. As we see in Windrush, if a case isn't won, you may get a government saying, however, we'll look at it. That might be what you've seen, but the legal avenues have ended. And in terms of the governments from the Herrera people, absolutely. It is an issue, and these governments are going to have to work with the reparations commissions, and they in turn, for some of these reparations commissions, particularly in CARICOM, I don't know so much about in the AU territories, and there certainly isn't any in the diaspora, although I think in the States there are a couple, are going to have to work with the people. Otherwise, it's going to be problematic. Settlements and agreements will be done. And Chagos is an interesting example of this, actually, because you've probably seen the UK Chagoans saying, there's been no consultation with them. They're terribly unhappy with the settlement. They've lost their homeland, and people are celebrating something that isn't really something to celebrate. So it's all very problematic. And I'm very, very concerned about how we go forward. I think that's as important as those of us who are lawyers who have to try and find the legal avenues. How we go forward, as Esther always says, about what is this, who is it, really does need to be answered.
Okay, thank you. We'll have another... Oh, sorry, Gretchen. I'm sorry. Yeah, okay. Unmute, yeah? Uh-huh. Can we unmute, please, at the back? Thank you. Okay. Okay, unmute yourself, Gretchen. Stop. Okay, we're not hearing you. Okay, all right, she'll come back. All right, we'll take a second round, and then we'll have concluding comments.
Hello? Is that working? No.
All right.
Hello?
I think it is.
Okay,
Hello?
I think I'm on now.
Okay,
Yes.
all right, we've got
So
Gretchen.
sorry about that.
Yeah, okay, Gretchen. Yes,
Yeah,
we can
really
hear
quickly
you.
on
I'm not very
really quickly on Tulsa. Yeah, no, we have been in conversation with the Justice for Greenberg. There has been actually an announcement by the DOJ. It's their cold case unit. It is very preliminary. I know as someone who's done a lot of litigation down there, it's generally also in consultation with the litigator. So we don't know if it will go anywhere. Relating to, and thank you very much for raising the exclusion of the recognized and elected leadership within the Overhera traditional authorities and their exclusion from the negotiation between Namibian governments. I think that's a perfect example, not only as to what we can learn, how we can build out even as lawyers, what we're advising our clients, as to the centrality of participation, not just about national participation, of those who were harmed, the wronged parties, needing to be at the table, because the own purpose of reparations is about being victim-centered. But then in addition, so how they are centered in our work, our litigation, I'll need to work a little bit better on that, I know I do. But then also in thinking through who can bring these claims and how can we open and expand more opportunities for those who are not represented by governments who wish to. And I gotta say, from working on the Haiti and the Namibia matters, I think that those are representative of what most of us experience. I know I live in a country where my government is not recognizing nor pursuing claims for reparations that I believe through my ancestry I'm entitled to. And I think that that's actually exists. That's the majority of spaces around the globe, not the minority. So looking into what as and can be done in our work with partners in Haiti, when you actually did not have elected government, and we were looking at what are the mechanisms, particularly the UN mechanisms that can be triggered. There are many by citizens. And then I believe that what happened in Namibia has to be raised and discussed everywhere to prevent that from occurring again. And there are incredible advocates who are speaking on that in other spaces. Thanks, I hope that addressed those two.
Thank you for that. The Namibian situation is a case, Swatby and others, which people should look at, where the traditional authorities for Nama and Overherero people have actually initiated legal action against the government of Namibia. Why? Because they are being denied, as Overherero and Nama communities, people, who are recognized as being peoples under the International Convention on the Rights of Indigenous People, are being denied their participation rights to actually be involved with the negotiations between the two governments, that is the Federal Republic of Germany and the government of Namibia. And they are being denied a seat at the table to discuss how genocide redress that they have survived should occur. The Namibian state is excluding the autonomous representation of the people who experienced it. And this is what's going on when we just focus on states. And the UN framework has been mentioned. It's a right of victims. Did the states that currently exist, were they the victims of the crimes that we are talking about? The states that were initiated and formed by Europeans, were they the victims? So let's not go down some kind of legal rabbit hole here, okay, around what we're doing, because we've heard our people are dying. And so the law needs to come up into this century, and the law must be fit for purpose. We need a law that actually doesn't legitimize conquest and imperialism and deny the participation rights of affected communities. And those states and any other international institutions must also respect human rights, people's rights, and Mother Earth rights, especially when they are seeking to utilize them in their advocacy with European states and powers. Now, just moving on to the second round of questions, and then we will have to close. Can you keep your questions or comments very brief? And then we'll hear back from our panelists.
Oh, yeah.
Thank you.
Thanks, Elsie, for this wonderful panel discussion. Just to Jackie's point about Tusla, thank you for bringing that up as well, because there are people today who suffered from abuses just as recently as the 60s, the 1940s. My name is Conrad Bryan. I'm chair of the Irish Racial Justice Forum. And we're a group of lawyers and human rights campaigners who are seeking reparations for children of African men who came to Ireland during the decolonisation of Ireland. And we found it tremendously difficult to get justice in Ireland because of exactly what you're saying. You're faced with statute of limitations, and you're just talking about people going back to the 1940s. We've got no class actions in Ireland. So we've had to go outside Ireland, and we've had a number of rapporteurs issue a public statement actually requesting remedies for these children who suffered human rights abuses in institutions, so long-term incarceration in institutions where they were subjected to vaccine trials and medical experiments. So we're talking grave human rights violations here. So we've gone to rapporteurs, they've issued a public statement by the UN, and the Irish government had ignored it completely. They actually specifically requested and recommended that the Irish government provide reparations and remedies. That was ignored to the extent that we've now had to raise a complaint in CERD. So we're now actively looking at CERD. There is no class action in Ireland. We're taking a class action in CERD. Don't call it a class action. It's a group of individuals. It's ongoing at the moment, so I won't talk about it, but Twail Review probably next week we'll have an article that will go into more detail. So my question for you really is in terms of CERD. I think CERD has its mechanisms within it to look at interstate complaints and cases, as you know. They've also got a mechanism within it to set up a commission within the CERD apparatus. So I think there's a lot we can do at the UN through the CERD, not just through the ICJ, but I'd like your comments or sort of views on that particular aspect.
Okay,
Thanks.
thank you. Thank you, Connor. Moving on.
Yeah. Hello, everybody. My name is Rennie Stevens. I'm the CEO of Menelite Business Life Forum. Can everyone see this picture?
Yes.
Can everyone see it? Yeah. Has everyone seen this video? Anyone seen it? Yeah. Basically, this is a prominent, as you know, Conservative Party member. She's saying that repatriation is a scam. She's saying that the British Empire, we should recognise the British Empire because they abolished slavery. So my question to the panel is, you know, she's a black woman, and she's saying it's a scam.
Okay.
So
yes.
how do we address? How are we going to get around people like her?
How do we address collaborators? Yes. Okay.
That's my question to. That's my question to the panel.
Thank you. Because people like to talk about the past, but let's deal with the present. Thank you. Moving on, buddy. What are you doing here?
Well, I couldn't miss this. This is the conference for 2024. So my name is Reverend Buddy Laria, and I want to say I've been an activist for social justice for 47 years. That's another story. However, my question is, if reparation is based on truth and justice, we must start at the beginning. I'm not going to be long.
Buddy?
No, I'm not going long. What I'm saying, the beginning is the colonization started based on the truth. Listen carefully to what I'm saying. When Columbus in 1492 returned to Spain, he told the truth. He said the people he encountered was peaceful, the land was rich, and the people were helpful because he experienced their help. His ship, the lead ship, was sank. He left 20 of his crew in where he landed, and the people assisted him. So he told the truth. And he said, if you give me ships and mercenaries, I could go back down there and we could yes, we could colonize them. So he told the truth. And 1 year later, they gave him 17 warships and 120 mercenaries that get from prison and went back. And then all hell broke loose. So we have misunderstood the 12th of October. The 12th of October was a day of truth, helpful, justice, everything that we as the people he encountered gave to him and his crew. So this is what has happened. In 2013, the World Social Forum proclaimed the 12th of October as the International Day for Reparation. And in 2017, 6 years later, the Caribbean community proclaimed the 12th of October Caribbean Holocaust Day. The 12th of October must be proclaimed now that we're going to have next year as reparation. The 12th of October must be proclaimed the International Day for Reparation towards truth, justice, peace, healing, and reconciliation. You get what I'm saying? Okay, and I'm saying that I've been at this now from a long time. Okay, so I'm saying that the time has come.
So you're making that as a recommendation in terms of the policy and legislative change and acknowledgement.
And that is to support what has already been put on the agenda. But a government has to put the resolution to the United Nations. The people cannot. You get what I'm saying? I mean, people must now ask the government, especially the government of Barbados, and let me say this is why. Because the government of Barbados is the first country in the world that passed the law that said that black people were not human beings.
Yes. Okay, thank you.
Thank you very much.
Reverend Buddy Larry, thank you. Yes. Okay, time is upon us. Can we be very brief because we are literally 2 minutes to the end of the session. Thank you.
Hi everyone, I'm Shadona Kettle. Thank you very much for your interventions. A question that I had related to what was mentioned about domestic litigation. Now, this was the rights of appeal to the former colonizing countries. So what happens when you have prime ministers in these countries that belong to the Privy Council? Can a case actually be brought to the head of state, which would, if you belong to the Privy Council, you're associated with the King's Council. So I'm just very interested in that, please. Thank you. Okay, thank you. We're going to hear the two last contributors and then we'll hear from our panel. Thank you.
Greetings all. Just a very quick question under the circumstances. What does the panel think about the Permanent Forum for People of African Descent established at the UN in terms of its ability to bring cases or calls for an advisory opinion from the ICJ? Yes, states have to be the parties, but advisory opinions, can we be represented by the Permanent Forum at the UN? Thank you.
Thank you.
Thank you very much. Very quickly, my question, forgive this maybe slightly rudimentary nature of my question. It is related to the question from our brother in relation to our dear sister Kemi and her comments. But from a media perspective, more people are accessing the issue of reparations right now from conversations in the mass media, yeah? Mm-hmm. And some of those conversations over the past week or so have conflated philanthropy and charity with reparatory justice and reparations, as well as business arrangements with reparatory justice and reparations. And some of it even tried to suggest that it would be more forward-thinking to engage in charity and business deals as opposed to reparations, to replace reparations. So my question, therefore, is from a legal perspective, what is the distinction between charity, philanthropy, business, and reparatory justice, yeah? And I'm speaking specifically here as media because we need to be able to promote this, the distinction from a media perspective as well. Thank you very much. Thank you very much.
All right, thank you. Thank you to all of you who have contributed. I know there's a lot more to say, but because of time, can we hear from our panelists by way of your responses, please? Thank you.
Yeah, sure. Thank you, everyone, for those wonderful questions. So I'll just pick up on the question about the UN Permanent Forum. So the process for requesting an advisory opinion from the ICJ is quite straightforward. The UN General Assembly has to request that the ICJ gives a judgment on a set number of questions. The way in which you do that is you have a vote of all of the countries that are members of the General Assembly, and if a simple majority, so just over half of those states, support that resolution, then it goes to the ICJ. So I think it's actually quite a relatively easy diplomatic campaign if you're saying to the Global South, Africa, CARICOM, that we want a case from the International Court of Justice. And I think that's one of the things that's encouraging about this area, and one of the reasons why I think a case is likely in the near future. In terms of representation then, once we get to the hearing stage, states can make submissions, but also intergovernmental organisations and bodies like the UN Permanent Forum. So the UN Permanent Forum would be represented, if it made a request, at the ICJ in that case. Just very quickly on the Privy Council question, great question. The Privy Council is a large, archaic institution. The relevant part of it that would deal with a legal case is the Judicial Committee. So it's not all of the members of the Privy Council, all of the ex-Tories and Labour MPs that they've appointed to it. It's just the judges. So it wouldn't be a conflict of issue with the Prime Minister. And then very quickly on CERD, sounds like fantastic work that you're doing in Ireland. I'll just say quickly that there is, obviously under Article 6 of the Convention, there is a remedy for victims of racial discrimination. The logic of a case submitted to CERD would basically be that communities that face ongoing discrimination,
being told to wrap up.
Certainly. Just very briefly, you would basically link it to the same communities who are suffering worse health outcomes, education outcomes, all the communities that are suffering the structural discrimination of slavery. You say that's an ongoing form of racism and therefore breaches that convention.
Okay.
So that would be the structure of the argument.
We have literally 1 minute to wrap up this whole session.
I'm happy to let somebody else then.
Okay, any other responses?
I would just jump in.
Then, if nobody wants to come in, I'll just quickly say this issue about distinguishing between philanthropy, charity, reparations is so crucial, which is why I say we do need a commission here in the UK to sort of, discuss these and try and establish what we're talking about. But I'll just rest it there, and hopefully we can do some follow-up work on that afterwards.
Thank you.
Yeah, jumping in on that.
Gretchen, please.
Jumping in on that distinction, and then absolutely, the reparations is about a state responsibility. Reparations is also, as I was saying, informed by our ancestors, not just by the law. And so what we can be doing in the process of getting to the win, instead of waiting until that there's a win, I think is our obligation. So I believe corporations, philanthropy, as OSF has, are resourcing the steps to get towards reparations, or corporations, if they're wanting to invest in the advocacy or the creation of tribunals to be able to pursue the government funds. But they are distinct, and most definitely development deals and agreements, as was the problem relating to Namibia, is not reparations. That has to be defined by the harmed party. The second on CERD, I'd love if people reach out to me. Yes, we've been working and we've been developing CERD petitions, both interstate and independent, for a number of different actions, and are really interested in being in communication with others about creating packages for those, because I do believe that with the current position and the current definition of the evolution of racial discrimination and neocolonialism, this is a very good time to explore that UN mechanism. Thank you.
Thank you so much to all of our panelists, Jacqueline, McKenzie, Harj, Narulla, Gretchen, Rohr, Corinne, Elle, and Clive, Baldwin, and to all of you. We need to move swiftly now for the closing panel in the main room. Thank you.